Hello, this is Michael O'Brien, and welcome to another video in our series on foreclosures in Oregon. Today, we're going to compare the two different types of foreclosure, but really focus on learning what type you may be facing. If you're an Oregon homeowner concerned with staying current on your mortgage, then this series is for you. Let's get right into it. If you need a refresher on foreclosure basics, we'll add a link at the end of this video, along with links to our videos on each specific type of foreclosure. But this video is about comparison. And step one is how to know what type of foreclosure you're facing. Now, foreclosures in Oregon can either be non-judicial, meaning out of court, or judicial, meaning in court. A non-judicial foreclosure is started by recording in the public records a notice of sale, also seen it called a notice of default and election to sell. Now here is a redacted copy of an actual notice. You can see that this references the name of the borrower, which of course we redacted. It lists a very specific document recorded in the public records of the county in which the property is located. It spells out the legal description of the property, lists the street address of the property, which again we redacted, provides a detail of the missed mortgage payments and the amount needed to cure the loan, along with the amount needed to pay off the loan. And then, at the top of page 2, it tells the specific day, time, and location where a public auction will be held to sell the property. Under Oregon law, the lender must give you at least 4 months notice of the non-judicial foreclosure sale. So that date I just showed you on the form will be at least 4 months after the document is sent to you. A non-judicial foreclosure ends with a public auction of your property, and anyone who buys property at that public auction must pay cash, or at least be pre-approved by the foreclosure trustee to bid. Most of the time, when property is purchased, it really is sold to the lender who's owed money. Now, we go into this in more detail in our videos specific to non-judicial foreclosures, but here are 5 key aspects to understand. Number 1, there is no judge to plead your case to. So if you do not agree with the lender, with its accounting or the process, typically you have to initiate litigation. Number 2, you can stop the sale by paying the loan current, so long as you do so 5 or more days prior to this date, the sale date. Within 5 days of the sale date, the lender can require you to pay the entire loan off. Number 3, once the sale is complete, it is final. The new buyer has a right to possession of the home 10 days after the sale. If you're not out by then, you can be evicted. Number 4, there is no right to redeem or buy back the property after a non-judicial foreclosure sale. Number 5, you could file bankruptcy to stop the sale up to a minute before that sale concludes. Now let's switch gears to judicial foreclosures. A judicial foreclosure is started by the filing of a lawsuit in the county in which the real property is located. And here is a redacted copy of an actual judicial foreclosure complaint. We call this part the caption, which tells you where the action is filed. It says, in the Circuit Court of the State of Oregon for the County of Columbia. We have redacted the case number that would normally appear here. The plaintiff over here is the lender who's bringing the lawsuit, and the defendants listed here are the parties being sued. We've redacted the client name, as well as the address of the property that would normally appear here. And over on this side, you can see what the lender is asking for in the lawsuit. In this case, a complaint for declaratory relief and judicial foreclosure of deed of trust. Okay. Since the judicial foreclosure is a lawsuit, you must appear to defend the case within 30 days after service, or you lose the right to contest it. At the end of a judicial foreclosure, the judge will sign an order telling the county sheriff to conduct a public auction of the property. And again, any buyer must pay cash or be pre-approved. Here are 5 key aspects of an Oregon judicial foreclosure, which we go into in more detail in our specific video on this topic. Number 1, this is a lawsuit. So you can defend it, you can seek an accounting, or countersue the lender or any other third party if they breached your loan contract. Number 2, you do not have a right to stop the judicial foreclosure by paying the loan current. Number 3, with a proper defense or counterclaim, a judicial foreclosure could take well over a year to conclude, giving you lots of time to solve the problem. Number 4, once the sheriff's sale is complete, you have 6 months to buy back the property. This is called the right of redemption. And number 5, because of that right of redemption, you can file bankruptcy up to 6 months after the sale and claw back the property, although we certainly don't recommend waiting so long. Now, hopefully you never find yourself in this situation, but if you do, hopefully now you can determine which type of foreclosure you might be facing and generally how the different types differ. As we've said many times before, if you find yourself struggling to stay current on a mortgage, educate yourself early. The sooner you start, the more options which may exist to help you save your home. If you call my office, the number below, and mention this video, my staff will set up a phone conference with me at no charge to you, where we can chat about your specific situation. Thank you much. Take care.